Well, with severe weather crossing across central Illinois, we've got tens of thousands of people out of power, but that doesn't slow down the news. Of course, we'll keep you updated on the latest developments on the damage assessment when we get it here for central Illinois. But across the states, a lot of attention was on what was going on up in Chicago at the 7th Circuit Court of Appeals, where the consolidated cases from the Southern District and the Northern District challenging Illinois' and local gun and magazine bans was heard by a 3-judge panel on the 7th Circuit Court of Appeals. Well, that was broadcast on YouTube, and we've got some of that for you. And let's go ahead and hear from the state's attorney that was there with the Attorney General's office talking about the arguments that they're making in this case.
I'm Deputy Solicitor General Sarah Hunger, and today I will be presenting argument on behalf of the state parties.
And the Deputy Solicitor General provided her argument.
We know from Bruen that courts must begin by assessing whether the regulated instrument is protected by the plain text of the Second Amendment. We also know from both Bruen and Heller that not all instruments fall within that category. The instruments must be arms, they must be bearable, and they must be in common use for self-defense. The instruments at issue here do not satisfy that standard for at least 2 reasons. First, large capacity magazines are not arms. They are accessories that are not necessary to the operation of any firearm.
And I take it when you say that, you understand some sort of ammunition feeding device needs to be there, but it could be a 10-round device, not a 30-round or something bigger.
Yes, of course, Your Honor. At issue here are only the large capacity magazines that are restricted by the Act. The Act does not restrict anybody's ability to use a magazine to operate their firearm. And
so you can hear at least some of the arguments there, and the justices on the 7th Circuit Court of Appeals asking questions as the attorney is providing her argument. And you had that happening all throughout the nearly hour-and-a-half hearing of arguments in defense of the law and arguments against the law. And we'll get to the arguments against the law here in a bit, but one thing that the state made clear in their arguments was trying to relate AR-15s to M16s and fully automatic versus semi-automatic, and they say it's not much of a distinction.
That's correct, and that's a really important point, Your Honor, because assault weapons are virtually identical weapons to M16s, but for one thing, which is that M16s can use automatic fire instead of semi-automatic fire. And sure, that is a distinction, but it is not one that's constitutionally determinative.
So that's the argument the state's making. Ultimately, there was another argument that was made from a different attorney at the 7th Circuit Court of Appeals yesterday.
My name is Assistant State's Attorney Jessica Scheller, and I will be presenting argument this morning on behalf of the county defendants.
And there was an argument made about regulating gun power as an historical analog to why gun laws are allowed. And you had a little bit of pushback from Frank Easterbrook in this particular argument.
Isn't the why for gunpowder, though, different than the why here? I'm on the second step of Bruen.
Yes, of course.
The why for gunpowder was to prevent fires and explosions. That's why they limited it, right? Isn't the why here different, whether it's public violence generally or a segment of public violence?
But the county attorney there said, well, it's, yes, different, but it's still about, things that can cause mass casualty events, and that's the connection they make with why they say they can prohibit the sale and possession of certain semi-automatic weapons. Well, now it's time for the plaintiffs to get up and make their arguments, and their arguments were really based off of a decision by Bruen and the New York State Rifle and Pistol Association versus Bruen in New York that was ruled on by the U.S. Supreme Court last year. Here's the attorney representing plaintiffs.
Good morning, Your Honors, and may it please the court. Erin Murphy, counsel for the Barnett plaintiffs.
And she started providing her arguments, and ultimately, Easterbrook broke in.
So I'd like you to consider the ban on machine guns in 1938. Was that unconstitutional? Because in 1938, machine guns were in common use, much as the AR-15 is in common use now.
I don't think so for 2 reasons. First, they actually were not nearly anywhere near as common as the AR-15s today. As the state's own expert has said,
there are a lot more weapons altogether now than then.
Certainly, but as the state's own expert said, they were not particularly common at the time. But more importantly,
they were especially common in Chicago.
What Heller said is that the reason they could be prohibited is because they were not typically possessed by law-abiding citizens for lawful purposes. Those are the precise words that Heller used in the specific context of explaining why Miller was consistent with the historical tradition of prohibitions on dangerous and unusual weapons. The court said what was different about machine guns was they were not typically possessed by law-abiding citizens for lawful purposes.
So Murphy continued on with some of her arguments, and the back and forth also continued with Easterbrook.
But what we are talking about here, these types of rifles that the state has banned, they're the second most popular type of firearm on the market after semi-automatic pistols. They're 3 times more common than revolver sales. They're twice as common as shotgun sales, twice as common as
But that gets
non-semi-automatic.
back to Judge Easterbrook's point about the Tommy guns and the like. I think just because, so your feeling is whatever it is that's popular, maybe grenades are going to be popular soon. That means that people have the right to keep and bear grenades.
Grenades seem to strike me as something that is more arguably not a bearable arm in the sense of a firearm
No,
that
a grenade is an easily bearable arm.
Pick it
That's
up.
the whole point.
Well, others are making the point, and this wasn't brought up in court, a grenade is indiscriminate. There's lots of collateral damage, different from a rifle that is very much a targeted instrument. So that argument wasn't clearly made. However, you had Easterbrook make, I think, statements that indicate to a lot of observers where this case is ultimately going to go. And the observers are saying that it looks like these appellate judges are going to side with the state and uphold the law. Here's Easterbrook.
Bruin confronted the question that was confronted in Bruin, which had nothing to do with arms like the AR-15. That's why both Justice Kavanaugh and Justice Alito filed separate opinions saying Bruin decides only what it decides, what it's presented. There wasn't any question in Bruin about what is a protectable arm.
So the conversation continued with other plaintiffs' attorneys. Thomas Magg, he was there, and he brought up the issue of how this is not about grenades, this is not about bazookas or anything of that sort.
Perhaps I want to start out by saying we're not here talking about Stinger missiles, bazookas, or the like. Frankly, I'm aware of no law outlawing them. National Firearms Act might tax them.
There is, in fact, a specific federal statute about grenades.
National Firearms Act. It's a
Also
tax
includes
statute.
body armor and a bunch of other things.
A bazooka, they're on the market, they're taxed and registered, as are pre-1986 machine guns, of which there are about 200,000 in civilian hands right now. But we're not here talking about rocket launchers and grenade launchers. In fact, machine guns at the federal level weren't banned until 1986. They were taxed and registered starting in 1934 by the federal government, but remained on the market. The reason that there's only 200,000 machine guns in civilian hands is they're expensive. And they were regulated, not banned.
So Magg, he continued on with his points about how this isn't about bazookas or grenades. This is about semi-automatic firearms that are in common possession and common use.
Be protected.
And therefore, in your view, is the Stinger missile protected by the Second Amendment?
Probably not, because it would be dangerous and unusual.
Unusual compared to what?
Compared to anything, even in the military, they don't issue man-pads, man-portable air defense systems like the Stinger missile to the average infantryman.
Oh, the average infantryman.
I mean, it's like nuclear weapons. Nuclear weapons, even in a military context, are rare and unusual. There might be thousands of them across the nation, but they're certainly not issued and used, at least not used since World War II.
So again, the arguments from the plaintiffs about those types of weapons that are in common use. Bazookas are not in common use for self-defense, and there's also, the issue of collateral damage versus targeted implements. So interesting to hear those arguments. So you had the state present their case, the plaintiffs present their case, and the state came back for rebuttal, and an interesting exchange between the defendant attorneys and the Judge Easterbrook here.
Right, but the rifle that made the West, the one where you could crank the pump and shoot again much more quickly than anything beforehand. And it would have a magazine of some number of rounds. It was not It was, in a sense, like its predecessors, but in a sense, it was the AR-15 of the day. Was it protected by the Second Amendment? Is it protected by the Second Amendment today?
Our view is that certain restrictions may have been lawful, for example, on the concealed carry of those weapons, which I believe were in existence in the 19th century, which may be different than a complete ban on those weapons, which, may not be protected for that purpose.
That sounds pretty fuzzy. Is that your final answer?
The Supreme Court has said that the restrictions on concealed carry of revolvers and rifles of those type are constitutional. And so it does depend on, I think, what the restriction is. So that is my final answer.
So there you go. That was just an overview of the hour and a half long hearing that happened yesterday in the Seventh Circuit Court of Appeals. When they make a decision, who knows? It could be months, but it's guaranteed whichever the decision goes. As some observers say, it's going to go by way of the state upholding the gun ban, or it could possibly lead to an injunction. Either way, it's going to be appealed to the U.S. Supreme Court. And whether or not that falls into the timeline of when people have to register their semi-automatic weapons they had before January 10th of this year. They have to register those by January 1st. Whether there's any clarity on how this is going to be dealt with by the U.S. Supreme Court before then, that's not certain here. But that also means you could see other lawsuits filed on Fifth Amendment grounds to try to block the law from being implemented in federal courts before we get to that January 1st deadline. So there's a lot of still moving pieces here on this story, and we'll be tracking it for you on WMAY. And I'm Greg Bishop with Springfield's Morning News.